January 13, 2023, we are going to continue on our journey through the affirmative defenses to negligence. Last class, we reviewed the elements of negligence. We discussed the first affirmative defense, which was contributory negligence. We did a case review for that first affirmative defense of contributory negligence, which was Wright v. Norfolk. And we ended class with the reality that the doctrine of contributory negligence is harsh. It's harsh, right? So today, what we're going to do is we're going to look at the doctrine of contributory negligence as it is related to the doctrine of last clear chance. Yeah, so we're continuing with the broad stroke of contributory negligence, but now we are going to add something a little bit different. We are going to add a doctrine that is the doctrine of last clear chance that was intended to operate as a rebuttal of sorts to the doctrine of contributory negligence, because we talked about how harsh that doctrine was. The last clear chance doctrine gives the plaintiff an opportunity to establish that the defendant had the last opportunity to avoid the injurious event, but failed to do so. So how does this look? Plaintiff comes in, establishes a prima facie case of negligence against the defendant. Defendant comes in and establishes a prima facie case of negligence against the plaintiff, asserting the defense of contributory negligence. We go home again, right? No. The plaintiff now gets to come in, and if they can, establish the requirements of the doctrine of last clear chance, asserting that while the defendant was negligent and while the plaintiff may have been contributorily negligent, it was the defendant who had the last opportunity to avoid the accident. It's starting to get juicy, okay? Under the last clear chance doctrine, the negligent plaintiff must prove that as between themselves, the negligent plaintiff, and the negligent defendant, that it was the defendant who had the last opportunity to prevent this horrible event, and they failed, okay? In order to do that, the plaintiff is going to have to show that the plaintiff was in immediate or actual danger as a result of their negligence now, that they were unable to extricate themselves. They were unable to remove themselves from that dangerous situation. The plaintiff would have to show that the defendant knew about the danger. The plaintiff would have to show that the defendant had a reasonable opportunity to avoid the danger and failed to do so. Yeah, this is getting good. So let's go ahead and look at the case that was assigned for today. That's the Coleman v. Hines case. Thank you so much for turning it in. I will get those back to you next week because, again, we are grading the briefs. So here we go. Coleman v. Hines. Remember the case? All right. In this case, we have a plaintiff who's deceased, right? Miss Musso. So What does that mean? That means that someone on Ms. Musso's behalf is bringing this lawsuit. In this particular case, it's the administrator who's bringing this lawsuit on behalf of the deceased plaintiff. The lawsuit that the administrator is bringing is a wrongful death action. So, administrator files the wrongful death action in the trial court, right? Seeking damages against the defendant. Now, mind you, this is something that's really important to keep in mind. Mind you, this defendant in a criminal proceeding has already pled guilty to involuntary manslaughter. Now, criminal proceeding, they've already pled guilty. All right, so here we go. Administrator files the lawsuit, trial court, wrongful death against a defendant who has admitted their responsibility for the death of Ms. Musso. Think this is a no-brainer. Think this is a home run for the plaintiff, right? So quick, the trial court actually ruled against the plaintiff, and the plaintiff appeals. So let's get into it. Again, I know that you've read it. I appreciate you reading it. I appreciate you being critical in reading it, which means that you're reading beyond the superficial layer of just the words on the page. You're really reading for the essence and the overall meaning of what this rule of law that they are speaking of means and how that gets applied. So what is the issue in this case? Well, the issue is really simple. We have a situation where we are in a jurisdiction that recognizes contributory negligence. We know that. It's not a question, okay? We know that the doctrine of contributory negligence says plaintiff establishes prima facie case against the defendant. If the defendant can in turn establish a prima facie case of negligence against the plaintiff, i.e. contributory negligence, plaintiff loses, done. We've already talked about how harsh that was. So here's an exception. If once the plaintiff has established negligence against the defendant and the defendant has established negligence against the plaintiff, if the plaintiff can establish that the defendant's negligence was more than just ordinary negligence, right? Was egregious somehow, was above and beyond negligent somehow, was reckless somehow, was willful or wanton somehow, then the plaintiff, in essence, trumps the defendant's assertion of contributory negligence. See what just happened? See what just happened? Look at it. Plaintiff says defendant is guilty. Boom. Defendant says, so what? You were also guilty of contributory negligence. Boom. We're now on equal ground, right? Both parties negligent, right? General negligence. This is the four check marks: the duty, the breach, the causation, the damages. Okay, so we're now on equal footing. Plaintiff goes home, right? No. Boom. Plaintiff one-ups and says, I may have been negligent, and my negligence may have met your degree of negligence. So we're both negligent. However, your negligence is so much more than my negligence. We are not on equal footing, and you should still be held reliable. So, in a jurisdiction that utilizes the doctrine of contributory negligence, if a plaintiff can establish that while they too may have been generally negligent as the defendant, if the plaintiff can establish a recklessness, a greater degree of negligence. Can they win? It's a good question. Let's see what Coleman v. Hines explains to us the considerations are. And let's see what Coleman v. Hines has to say about this doctrine of the last clear chance. Key facts. There's a lot of them. As I explained before, I'm not going to put them all on the PowerPoint, right? That's going to take up too many slides. And it's redundant because you've done that work. We've talked about key facts being those facts that turn the case. Those facts that are so important that if that fact didn't exist, we wouldn't have a case. Okay? So key facts. One of the facts, the one that I wrote here, is a key fact, which is that the defendant pled guilty to involuntary manslaughter. That's huge because that's almost the prima facie case, right? Right? So that fact in and of itself is so important, we list that. What are some of the other important facts? How about the fact that Ms. Musso, the deceased plaintiff, worked at Domino's? Is that an important fact? Does that turn the case? But for the fact that Ms. Musso worked at Domino's, would we be here? It's not that important of a fact. It doesn't even matter that she's working, really, right? Right? So that's not a fact that I'm going to include. What about the fact that the defendant had been drinking since that morning and went to Ms. Musso's place of employment where she could see that he had been drinking? That an important fact? Important, right? Because it helps establish that he's been drinking all day. What about the fact that we have the testimony from Ms. Musso's supervisor at Domino's who says he was drunk when he came to see her at work? That came in as testimony. It was allowed in as evidence. So it was considered by the trier of fact. That's an important fact. What about the fact that the supervisor of Ms. Musso testified, I asked them to please not go out and drink and drive. I asked them to allow me to take them. I would have not chaperoned, but I would have chauffeured them back and forth. I would have driven them, right? Because this could end in nothing but disaster. That's a pretty important fact. The fact that they declined the supervisor's requests to be their personal Uber. That's a pretty important fact. So we're not going to go through any more of the facts because you've gone through them. And again, I'm going to read all of them and grade all of them. But that's what you're looking for. Some people call them key facts. Like these facts lead to the key, or these facts are the key and the reason that we're here. Some of us will call them dispositive facts, but for that fact, we wouldn't be here. Some people call them relevant facts. Because if it's irrelevant, it doesn't really matter to the merit of the case. Whatever you call them, understand that in a test-taking situation, you might list some facts that are not necessarily dispositive. And assuming that this isn't a identify the dispositive facts test, right? You probably don't lose points for that. But when it comes to test taking strategy, what you lose by adding facts that are not necessary is time. Right? You're in a timed situation where you have a finite amount of time, and the 10 seconds or the 20 seconds or the minute or the 2 minutes that it takes to type or write facts that are not really dispositive is time that you're not going to get back, which could be time that you're not going to get someplace else. So If your brief that you just submitted to me has a whole bunch of extra facts in it, not going to miss any points as long as you identified the key facts. But you might want to start to practice on honing in on those dispositive key facts so that when you're taking tests, whether it's in torts or any other class, you have built a process by which you have streamlined that part of it. All right, so let's move on. We've talked about enough of the key facts. Now, let's talk about the rule of law. You want to talk about the rule of law now? Yeah, we can talk about the rule of law. What did this court use? What formula did they use? What code of interpretation did they use? How did they answer the question about whether or not a generally negligent plaintiff and a generally negligent defendant case ends there under the doctrine of contributory negligence, or case continues to live if the plaintiff can show that the defendant was more than just generally negligent. What is more than just generally negligent? Reckless, willful, wanting, egregious. You're looking for those facts that say, whoa, right? This is so much more than just a breach of duty. So in doing that, the rule that Coleman v. Hine gives us is where a plaintiff is found to be, here's the magic word, term of art, just as guilty of the negligent act that causes the plaintiff's injury as the negligent defendant, and the negligent plaintiff is just as guilty to the recklessness or the willfulness or the wantonness or the egregiousness behavior as in the negligent defendant. In a contributory negligence doctrine, the plaintiff is barred from recovery. Boom. So whether you want to be specific and say the court found that the plaintiff was negligent and the court found that the defendant was negligent under contributory negligence doctrine, plaintiff loses, right? In addition, the plaintiff found that the defendant was grossly negligent or willfully negligent or wantonly negligent or egregious in their negligence. And the court also found that the plaintiff was willful or wanton or egregious or reckless in their negligence. See what's happening? Just as guilty. Just as guilty. And that's what the court found here. Just as guilty. Let me pass by the secondary rule for a second because I want to get you to the reasoning. Just as guilty, right? Applying the logic, this is what the court said. We hold as a matter of law that under the facts of this case, the actions of the decedent, Ms. Musso, rose to the same level of negligence as worked. I don't see a lot of cases where the parties are identified by their first name. This case does that. That's not good practice. Just want to make that note. But they're equal in their negligence. They're equal in satisfying that basic level of negligence, which is the negligence that we always look for, right? If negligence is what we're looking for. But they're also both just as negligent on that higher level of negligent, that willful, that wanton, that egregious, that reckless level. So the plaintiff is just as guilty as the defendant in this case, which means the plaintiff is barred. Yeah. Now let's go back. There's a secondary rule at play in this case. We've already talked the rule about general negligent to general negligent, plaintiff is barred. Plaintiff tries to one up it and say, yeah, I may be general negligent, but your negligence is much more than general. It's reckless, it's wanton, it's willful, it's egregious. Therefore, defendant, you should still pay me. The defendant has the ability to assert, hey, same against you. And if the court or the fact finder believes that y'all have both risen to a egregious level, to a reckless level, to a willful level, to a wanton level, plaintiff is barred. That addresses that part of the issue. But remember, our issue introduced the idea of the last clear chance doctrine. Now, because the facts of this case are found the way that they're found by this appellate court, we don't really get to the doctrine of last clear chance because it doesn't apply here, because the plaintiff is barred here, because the plaintiff is as reckless, as egregious, as willful and wanton as the defendant. So that ends our case legally. But the goes on to explain that if the plaintiff was not as egregious, as willful, as wanton, right? If the plaintiff's degree of negligence didn't meet this heightened degree of negligence of the defendant, then we would have to consider the doctrine of last clear chance. And so let's talk about the doctrine. The court tells us, if the negligent plaintiff is able to show under the doctrine of last clear chance that the negligent defendant failed to use every reasonable means to avoid the impending injury, then the plaintiff may recover. Now, remember, that's not happening here because the negligence on both the plaintiff and the defendant was matched, right? Matched. But if it wasn't matched, this is what it's going to look like. If the negligence isn't matched and the acts of the defendant are wanton or willful or reckless or egregious, and the acts of the plaintiff don't rise to that level, in order for the plaintiff to recover, the plaintiff's going to have to do 5 things. Number 1, the plaintiff is going to have to establish that by their own negligence, they placed themselves in a position of peril for which they could not escape. Number 2, the plaintiff is going to have to show that the defendant saw, or by exercise of reasonable care, should have seen and understood the perilous position that the plaintiff was in. Number 3, the plaintiff is going to have to show that the defendant had the time and the means to avoid the injurious situation. Number 4, the defendant failed or refused to use every reasonable means to avoid the impending injury to plaintiff. And number 5, that the plaintiff was injured. Got it? So if I can one up, if I can rebut, if I as a plaintiff can overcome contributory negligence defense, I may be able to recover if I can show these 5 things. So for the sake of practicing our analysis, let's pretend that, I'm sorry, I got a little note about my microphone, so we'll have to check that out. Let's pretend that the plaintiff in this case was not just as grossly negligent and was able to make it to the next level of this, let me now assert the doctrine of last clear chance. 5 things that the plaintiff has to establish. Number 1, that the plaintiff, by her own negligence, placed herself in a position of peril from which she could not escape. Stop. All right. We stop right there, right? Why do we stop right there? Because while this plaintiff would be able to show that by her own negligence, she's drinking with the driver who's drinking. She gets in the car with the driver that she knows is drinking. That's her negligence. She put herself in that perilous situation. But she could have escaped from that situation, right? How could she have escaped? She could have just very easily not gotten in the car. She could have very easily just accepted the ride that her supervisor was offering her. Right? It wasn't as though she was kidnapped and unable to remove herself. Because she was able to remove herself, we would never get to question 2, 3, 4, or 5 if we're able to even assert this doctrine, because in this current situation, it's not available. Got it? So let's get to the holding. The court affirmed in part and reversed in part. If you are responding to your holding as a yes and a no, you've got to be mindful that there are times where the answer is both yes and no. So when I ask you for the holding, I'm asking for what this reviewing court did. What action did this reviewing court take? Did they affirm? Did they reverse? Did they vacate? Did they reverse with modification? Did they reverse, or did they remand with instruction? What action did this court take? Here, the court affirmed in part and they reversed in part. What did they affirm in part? They affirmed the lower court's holding that the petitioner was barred because she was, and there was no genuine issue of material fact. So when the plaintiff filed a motion for summary judgment, it should be granted. The reviewing court, this court, reversed the lower court's ruling and found that there's no genuine issue of material fact of the gross negligence of both parties. It is clear from the facts that both parties were negligent. So again, the summary judgment motion as to the issue of general negligence and the summary judgment motion as to the issue of recklessness or gross negligence, there is no genuine issue of material fact. And that's how this case ends. Reason for the holding, here you go. And now let's take a question. A state statute provides that on roads without sidewalks, a person should walk on the road, or should walk on the left side of the road. We've seen this. Jill is walking down the road on a vacation resort. We've seen this. It is Friday morning and there is a great deal of traffic coming into the resort. However, there is very little traffic on the right side of the road. Jill stops to rest along the road because it is a really long road and it is a really hot day. While resting, Jill falls asleep on the side of the road. Jack is driving on the right side of the road. Jack is participating in a Zoom meeting while he is driving. Jack is not paying attention, does not see Jill until it's too late. Jack hits Jill. Jill suffers major injuries. Jill sues for negligence, and we are in a contributory negligent jurisdiction. What now? What happens? If Jack proves that Jill's contributory negligence in a jurisdiction that uses the doctrine of last clear chance, what happens? Will Jill recover nothing because of her contributory negligence? Will Jill recover nothing because of her contributory negligence unless the jury determines that Jack had the last clear chance? Will Jill recover nothing if she was more negligent than Jack? Will Jack and Jill split the damages equally? There was a question in class that suggested Jack participating in a Zoom meeting was gross. Not like ew, gross, but grossly negligent. Was egregious. So the question now becomes, right, because we know that she's walking on the wrong side of the road according to the statute. So we know she's negligent, right? Negligence per se, violation of a statute. And we know that he's negligent because he's not really paying attention to the road, right? He's distracted. He's a distracted driver, right? If you want to argue that Jack's Zoom call is grossly negligent, then you would have to make a determination. Is Jill deciding to take a nap on the busy road egregious? Is that reckless? Is that gross? Right? And if so, then that means that Jill's negligent behavior rises to the same level of Jack's negligent behavior. So we know that it's not equal, right? We know that it's not C because we don't even name a defendant, right? Is it Jill will recover nothing because she contributes to her negligence, or she contributes by her negligence to her injury? Or is it that she recovers nothing unless the jury determines that Jack had the last clear chance? What are your thoughts? I'm going to leave that one with you. We're not going to solve it together. I'm going to encourage you to think it through. And if you'd like to talk to me about it, 24 hours a day, 7 days a week, except for the time that I'm in class. Questions? That is the completion of the doctrine of contributory negligence. We've talked about the doctrine itself, and we've talked about an exception to the doctrine. We've gone through those two cases, and we are now complete again in our discussion of the first affirmative defense that we will cover, which is the doctrine of contributory negligence. Have a great weekend. Be safe. Look at the syllabus that's provided, because I still don't have access to my email. Don't know that I have one. I still don't have access to my Canvas because I don't have access to my email, which means you don't have access to your book. However, you do have your syllabus. So go ahead and read the next cases. Have a great weekend. Thank you.